Bismillahir Rahmanir Rahim. We have just spoken about the conditions of al-qisas. Let us continue on with the hadith. So hadith number 1018. وعن ابن عباس رضي الله عنهما قال قال رسول الله صلى الله عليه وسلم من قتل عميا أو رميا بحجر أو صوت أو عصا فعقله عقل الخطأ ومن قتل عمدا فهو قود ومن حال دونه فعليه لعنة الله أخرجه أبو داود والنسائي وابن ماجه بإسناد قوي. From Ibn Abbas, the Prophet said, whoever is killed blindly or through somebody throwing something and it accidentally hits him and kills him with a stone or a whip or a stick, then his blood money will be the blood money of accidental murder. And whoever is killed on purpose, then in this case the awliya will have the right to retaliate. And whoever objects to this retaliation, then upon him is the curse of Allah. The hadith is sahih. The blind killing is when somebody is killed and it is not known who the killer is. So this could be, for example, when a group of people are making tawaf during the Hajj time or stoning the Jamrah. There is a great rush and deaths have been known to happen. So somebody must have been the cause for somebody else to die because of the huge rush. So this is a blind type of killing. You don't know who the killer is. Or you could have two groups of people who are fighting each other and there is some fitna between them, and out of this chaos we find some people who are dead. Now we don't know who is the killer. And it could be that the killer didn't actually intend particularly to kill this person. It's just out of the chaos and anarchy, deaths are likely to happen, or at least they are a real possibility. However, the victim, his blood must not go wasted. Blood money must be paid. But in this case, the treasury of the Muslims, the Baytul Mal, will be responsible for paying the blood money to the family of the victim. And the blood money will be the blood money of accidental murder. And the same thing if people are throwing something, let's say stones or sticks or something, and they accidentally hit somebody and it results in a death, then the blood money will be the blood money of accidental murder, because the killer did not intend to kill the victim. As for if it's intentional murder, then as the hadith said, the awliya will have the right to retaliate. If they don't retaliate and kill the killer, then they can take blood money, of course, and the blood money will be severer than accidental murder blood money. However, there's a difference of opinion amongst the scholars. Can the awliya of the victim take more than the stipulated blood money? So more than the 100 camels which are stipulated, and we'll talk more about that in the chapter of blood money. As for if somebody intentionally throws a stone at somebody else, then this does not normally lead to a death, as we discussed in the hadith of the two women from Hudayl, where one woman threw a stone at the other, killing the victim and also the child in her belly. So this is, from one angle, unintentional because she did not mean to kill the victim, but from the other angle, it is intentional in the fact that she intended to harm the victim. And so because of this, some scholars have said that the blood money for the quasi-intentional murder would be a lot heavier, and it would resemble the blood money given for intentional murder, not the blood money given for purely accidental murder. We also learn that anyone who tries to object to this retaliation, or even to the blood money, then he's objecting to the strict and clear law of Allah Jalla wa Ala, and so therefore he will have the curse of Allah, which means that Allah removes him far from His mercy. And so it becomes known to us that this type of action is a major sin. If in the case that a person comes and he acknowledges that he murdered somebody else, and that's the only evidence we have of this murder, it's his confession alone, but then he says that this murder was accidental, it was not intentional, such that the awliya could take revenge, then if his statement is the only thing we have to go by and we don't have any other evidences which may shed light on this affair, then we would accept his statement that the murder was accidental. Anyone who claims that the murder was not accidental, it was intentional, then he would have to provide the evidence. But as long as we only have his statement to go by, then we would have to accept his statement that the murder was accidental. Because we are not allowed to impose upon him anything more than he has confessed to, except if we have other evidence to justify this. But if we don't have any other evidence to justify this, then we are not allowed to impose on him more than what he has confessed to. Hadith 119. وعن ابن عمر رضي الله عنهما عن النبي صلى الله عليه وسلم قال: إذا أمسك الرجل وقتله الآخر يقتل الذي قتل ويحبس الذي أمسك. رواه الدارقطني موصولا ومرسلا وصححه ابن القطان ورجاله ثقات إلا أن البيهقي رجح المرسل. From Ibn Umar, the Prophet ﷺ said, if one man holds another person, and then another man comes and kills that person who is held, then the killer is to be killed, and the one who held the victim, he is to be imprisoned. This hadith is sahih, and others have graded it to be mursal, which would then render it to be da'if. This hadith is extremely interesting and useful to know about, memorize and understand. So in this hadith we have a scenario: person A goes to a person B and he holds him, and then person C comes along and stabs person B to death. So person A was doing the holding and person C was doing the stabbing. This hadith tells us that if this is the case, then person C is to be killed because he directly undertook the murder, and person A is to be imprisoned because he did not directly undertake the murder, but he was responsible still for the murder because he was a cause for person B dying. How long is person A to be imprisoned for? He is to be imprisoned for life until he dies. This is how some scholars have said it, but it could just come down to the ijtihad of the hakim. This is how the Hanabila scholars have said it, that if person A and C were to conspire to kill person B, so one holds and the other one stabs him with the knife, then this is how the ruling is to be carried out. And they say this is the ruling as long as the one who is holding, so person A in this case, as long as he knew that person C is going to kill person B. So basically there was a conspiracy to kill person B. As for if person A did not know that person C was going to kill him, then they say that the killer will obviously be killed, so this is person C in this case, but person A, the one who was holding, there would be no punishment upon him because he did not conspire to kill person B. And so with this, we find that the hadith is in accordance with the qaida that we have, that if we have a cause and a direct action which come together, then the one who undertook the direct action is responsible, not the one who is the cause, as long as you can take to account the one who undertook the direct action. So for example, one person digs a hole in the ground where people are walking. Of course this is a silly thing to do, it could lead to death. But then another person comes along and pushes an innocent man into that hole, and the man dies. So who's responsible for the death? Is it the one who dug the hole, or is it the one who pushed the bystander? Well, we say the one who is charged with murder would be the one who pushed the bystander, not the one who dug the hole. And so this hadith is similar. One person held him and the other one killed him directly. So we take the direct killer to account. Imam Malik is of a different opinion. He says that both person A and person C in our scenario must be killed, as long as they conspired to kill person B. So they agreed, they said person A is going to hold him and person B is going to stab him, and this is how he's going to die. Now the point is this, that if it wasn't for the fact that person A held him, then person B may still be alive because he would have a chance to fight back or to run away. So the action of person A, even though it's not killing person B in and of itself, when you hold somebody you don't kill them, do you? But it had a real contribution to the murder of person B. It doesn't even have to be a physical contribution. It could be the case that person A is spying on person B and giving person C some secret information, like some secret intelligence. And this enables person C to plan out his route and go and kill person B. So again we have the same scenario. Person A and C are conspiring to kill person B, and person C would not be able to directly kill person B if it wasn't for the valuable information given to him by person A. So in a case like this, upon this opinion, both person A and C are to be killed because they conspired to kill person B. And the contribution of person A was such that it had a real effect on the death of person B. And upon the opinion of Imam Malik, if person A holds person B, but he does not think that person C is going to kill person B, but it so happens that person C does kill person B, then in this case person C obviously is to be killed or worthy of the death punishment, but person A is not to be killed, because he did not conspire to kill person B. At best he can be given a ta'zir punishment. So as for this qaida of the mutasabbib and the mubashir, the one who is the cause and the one who is directly undertaking the action, then we say that the one who directly undertakes the action, he is to be held accountable, unless it be the case that the one who directly undertakes the action cannot be held accountable. For example, somebody throws another person in a lion's den and the lions eat him up. The lions cannot be accountable for their actions, so in this case it's the cause who will be taken into account. So that's the first case. The second case is when the direct action is completely results from the cause. So for example, two people testify that person A killed person B, and so person A is put to the sword. And then these two witnesses, they come forth and they said that we lied, we actually wanted person A to die. That's why we gave this false testimony. Now, we had the worker of the Hakim who carried out the punishment of the retaliation. Is he to be killed? The answer here is no, he is not to be killed, because his action was as a direct result of the cause being, of course, the testimony. So therefore, in this case, the witnesses will be put to the death, both of them, because they conspired to kill person A. So in this case now, it is the mutasabbib, or the one who is causing the result, who is taken to account, not the one who directly undertook the action. So it's a similar situation here. Person A held person B, as both A and C conspired to kill person B. So the direct killing of person C was a direct result of person A holding person B. Therefore, we would have to take person A to account. Whereas in the situation with the manhole being dug, then the one who directly pushes the bystander into the hole is not a direct result of the manhole. They are two separate incidences. It's very possible that the first person digs a hole and the second person does not push the bystander into the hole. However, upon the opinion of Imam Malik, if person A and C conspire to kill person B, so A says that I have the manpower and the ability to dig a hole, and you, person C, push person B into the hole so he dies. So clearly they have agreed with each other, and this is therefore a conspiracy. So because of this conspiracy element, the pushing of person B into the hole is a direct consequence of person A digging the hole. Therefore both person A and C are to be retaliated against. So basically, it's the conspiracy element which you need to look at here based on this opinion. If there is a conspiracy to kill an innocent person, then everybody involved in this conspiracy needs to be put to the sword if their actions sufficiently contributed to the death of the innocent person. Hadith 1020, وعن عبد الرحمن ابن بيلماني أن النبي صلى الله عليه وسلم قتل مسلما بمعاهد وقال أنا أولى من وفى بذمته. أخرجه عبد الرزاق هكذا مرسلا، ووصله الدارقطني بذكر ابن عمر فيه وإسناد الموصول واه. From Abdurrahman ibn Baylamani, he says that the Prophet killed a Muslim because this Muslim killed a mu'ahad kafir, and the Prophet said that I am most worthy to uphold my contracts. The hadith is da'if. This hadith seems to be telling us that a Muslim can be killed for a kafir, but we have previously said that a Muslim cannot be killed for a kafir. This is the correct opinion. And some scholars, they take this hadith to prove that a Muslim can be killed for a kafir. They take this hadith and also the generality of the evidence which talks about a soul for a soul. But we know that the generality has exceptions to it. As for this hadith, then firstly it is weak, so we cannot go by it. But even if it was authentic, then we can say that the Prophet killed this Muslim not as qisas, but as a ta'zir punishment. It could be that certain Muslims have this twisted idea that you can just go around killing any kafir in an Islamic state, even if the kafir is protected. Well, this is foolish, and if need be, the hakim can kill these types of Muslims to show the general people that this is a wrong action which they did, and if you were to do the same thing, then you'll have the same fate coming to you. So we can say that ta'zir can be given, but this is different to a qisas. Or we could interpret the hadith to say that it is the qatlul ghila, the type of killing in which you take somebody out unaware. With this type of killing, the killer must be killed, even if the awliya of the victim forgive him, because the qatlul ghila is clearly a breach of the peace in the society, where the victim could not even defend himself. So this type of killing is far worse. And so many scholars have said that if it is a case of the ghila killing, then a Muslim can be killed for even a kafir. And this is a good opinion, because the Imam needs to ensure that there is peace and security and there is no treachery in his land. Transgressing against another person's right when he does not even have the chance to defend himself is far worse than transgressing against him when he does have the chance to defend himself. So it is for this reason that if you were to steal somebody's possession when he is unaware of it from his private dwelling, then your hand is cut off, and that's obviously a severe punishment. But if you walk in front of his face and physically snatch his possessions off him and run away, then lo and behold, even though you are worthy of punishment, but your hand is not cut off. Why? Because the victim had a chance to defend himself. And so with this hadith, if it is authentic, then we can carry it on one of two meanings. Number one, that this is a ta'zir punishment, and number two, that this killing was a ghila, and in which case, it doesn't make a difference who kills who. A Muslim kills a kafir, kafir kills a Muslim, whoever. As long as they are ma'soom, then this is the only thing which matters. Otherwise, killing a mu'ahad, we know, is a major sin. The Prophet ﷺ said, "Man qatala mu'ahadan lam yurah ra'ihat al-jannah." Whoever kills a mu'ahad, he will not even smell the fragrance of Jannah. Hadith 1021, وعن ابن عمر رضي الله عنهما قال: قتل غلام غيلة فقال عمر: لو اشترك فيه أهل صنعاء لقتلتهم به. أخرجه البخاري. From Ibn Umar, he reports that a boy was killed as he was taken unaware. And so Umar said that if the people of Sana'a were to gather together to plot to kill this boy, I would have killed all of them just for this one boy. Al-Bukhari reported it. We find in this scenario that a group of people plotted to kill one boy. There were about 4, 5 or 6 of them who plotted to kill the boy, and Umar radiallahu anh killed each and every one of them for this one boy. And this ties in with the opinion of Imam Malik that if a group of people conspire to kill an innocent person, then they are all to be killed as long as they all sufficiently contributed to the death of this person. So this could be in terms of giving intelligence information, it could be in terms of holding him back, it could be in terms of setting a trap for him, maybe in terms of deceiving him and gaining his trust so that the other person can kill him. Just any way, basically it needs to be a conspiracy. And as for the ghila, then are the perpetrators to be killed by way of obligation by the Imam? There's a difference of opinion, and we said that one opinion is that they are to be killed as an obligation. And upon this opinion, it wouldn't even make a difference if a kafir is killed by a Muslim. As we mentioned in the previous hadith, that a Muslim is killed for a kafir if it is a ghila. So this narration is evidence that the person who kills out of ghila is to be killed by the Imam. But also they have further justification. They say that the ghila killing is a type of hiraba, when you declare war on the community. So this would be people who lie in wait of innocent people, they would rob them, they would steal from them, they would kill them, they would scare them. So a very severe punishment is meted out to these types of people, and this is something we need to speak more about when it comes to the had punishments. But Allah says in Surah Al-Ma'idah, Ayah 33, إنما جزاء الذين يحاربون الله ورسوله ويسعون في الأرض فسادا أن يقتلوا أو يصلبوا. Al-Ayah, that the ones who declare war on Allah and His Messenger and they strive to cause mischief in the land, then their reward is that they should be killed or crucified up until the end of the ayah. The punishment is extremely severe, and so this is a type of hiraba, when you declare war on Allah and the Messenger. Also, with the evidence of the Yahudi killing the girl, this was a type of ghila. He killed this girl in order to take the jewelry from her. The point here is that the Prophet did not go to the awliya of this girl to ask if they wanted qisas or not. Rather, he simply declared that the man is to be killed, because this was a type of hiraba against Allah and His Messenger. And similar is the narration of a couple of men who came to Al-Madinah as they converted to Islam, and then they became ill, so the Prophet sent them to one of the shepherds to let them drink the urine of the camel. And what happened is that they apostatized and they killed the shepherd and they made away with the camels. And so the Prophet meted out an extremely severe punishment on them. And this is an issue which we should discuss in a bit more detail in the chapter of the had punishments. So this narration of the chapter, the narration of the two men who killed the shepherd of the Prophet, and also the narration of the Yahudi who killed the young girl, these are examples of hiraba. And so it is not necessarily a qisas which takes place here, but rather the Imam needs to kill these people off in order to preserve the safety and security of the land. Okay, what about the other way around? One person kills a group of people. Let's say one person kills 5 people. Who takes the revenge? Well, we say that the awliya of the first victim can take revenge. As for the other 4 victims, they will not be able to kill him, of course, because you cannot kill a person more than once. So the other 4 will be entitled to the blood money. As for the one he killed first, then they will be entitled for the qisas if they want to. And just in case if somebody says that we will not follow the opinion of Umar radiallahu anh because he's not a prophet and he can make mistakes as well, can he not? But the answer is that following Umar is in fact following the Prophet, because the Prophet ordered us to follow Umar radiallahu anh. So we would follow him in all that which does not contradict the Quran and the Sunnah. And even without evidence, this ruling still makes sense, that a group of people will be killed even if they killed just one person, as long as they conspired to kill him. Because then if somebody wants to kill another person and he knows that if he gets caught he'll be killed, then he can simply enlist the help of an aide of his, so they both conspire to kill him. So if he knows that a group will not be killed for a single person, then this will encourage murder, because then a person can just enlist the help of an ally. However, what if the awliya of the victim forgive the group of people who killed their relative and they demand blood money instead? What's the answer here then? Does each of the killer have to pay a full blood money, or do they divide it up? So for example, the blood money of intentional murder is 100 camels, and let's say there were 10 killers. Do they each pay 10 camels, or do they each pay 100 camels? Well, the answer here is that they each pay 10 camels, so 10 times 10 is 100. So the full blood money for one life is given. And the reason why they share it out in this case is because blood money can be divided, whereas a killing cannot be divided. If 10 people unjustly killed one person, you cannot give each of them a tenth of a killing. Of course, that's impossible, whereas the blood money can be divided, so that's the difference. Okay, what about this situation? Person A forces person B to kill person C. For example, he sticks a gun to person B and he says that if you don't kill person C, I will shoot you. And so person B kills person C. Of course, this is intentional murder. And let us suppose that all the conditions of al-qisas are met. Then, who is to be killed in retaliation? Is person B going to be killed? Or is person A going to be killed because he forced person B, and perhaps person B didn't have a choice and he killed the other to save his life? Or are both of them going to be killed? We have a difference of opinion here. Some say only person B, some say only person A, and some say both. But the opinion which says that person A is going to be killed and not person B, that is the weakest of the opinions. Because if anything, it should be the other way around. The one who directly undertakes the action, he is responsible. And person A did not directly undertake the action, he was the cause of the killing. And the opinion which says that both of them are to be killed is clearly understandable, because both person A and B in this scenario are zalim. They both are the oppressors. Person A has no right to force person B to kill person C, and he has no right to threaten person B's life if he does not kill person C. So the murder of person C has much to do with person A, and then person B is also a zalim because he has no right to take somebody else's life in order to save his own. At the worst, he would have to take the bullet from person A, or at best he would have to defend himself from person A, but certainly he has no right to transgress the rights of person C. So in a case like this, we would leave it to the Hakim. He may decide to kill both of them, or he may decide to kill person B only, because he was the one who directly undertook the action, and person B did not have to directly undertake this action. If need be, person B would just have to take the bullet. So we say that in a case like this, the Hakim would make his ijtihad in accordance with what he feels to be the truth and the most rightly guided action to take. What about this? If person A sticks a gun at person B and he says, "Kill yourself, otherwise I will kill you." So if person B kills himself, then is person A responsible? Because clearly person A did not directly kill person B. Rather, we find person B killed his own self. And of course he didn't have to do that. In a case like this, if person B kills himself, some scholars say that person A is responsible for his death because he forced person B to kill himself, and other scholars say no, he didn't force person B to kill himself. Person B just killed his own self, because either way person B was going to die. Therefore, if person B either way is going to die, then let somebody else kill him rather than kill himself. We know killing yourself is haram. So based upon this opinion, the latter one, there is nothing upon person A, and upon the first opinion, person A is held responsible. And the latter opinion appears to make more sense, because certainly person B is not forced to kill himself, and for him to kill himself, he's not gaining at all. So if he's going to die either way, then let him die at somebody else's hand rather than committing suicide, which is a major sin. Okay, what about this? Person A wants to kill person C, but he does not want to do it directly. And instead of forcing person B to kill person C, he pushes person B on to person C, who in turn falls off a cliff because he's standing near a cliff, so he falls off and dies. Who's responsible here? Well, the point is that person B directly undertook the action which killed person C, but it was unintentional. The intentional action here came from person A, therefore he is held responsible. So here we have a cause and the one who directly is responsible, but the one who is directly responsible cannot be taken into account. Much like if you were to throw another person in a lion's den and the lion eat him up, the lions cannot be taken to account. So in a case like this, the sabab needs to be taken into account. The sabab, of course, being the cause, the indirect cause. What about if a person orders a young boy below the age of adolescence to kill somebody, and the young boy kills that other person? Who is held responsible? Well, the boy cannot be held responsible because he does not have a valid intention, because he is not baligh. Therefore, the one who ordered the boy to do the killing, he is held responsible. So even though the boy was directly responsible for the murder, we have this lion's den scenario which we spoke about. Or for example, if a man who knows that killing is wrong orders somebody else to do the killing, and that person, the intermediary, he does not know that murder is wrong. For example, you could have 3 people on a journey, and they have lost their way, they don't have anything to eat, so person A, who knows killing is wrong, orders person B to kill person C so that both A and B can eat his meat. Otherwise they're going to die out of hunger. Now person B thinks that there's nothing wrong with killing somebody else to eat his meat if you yourself are about to die out of hunger. But person A does know. So in a case like this, the one responsible will not be the one who directly undertook the murder, who is person B, rather, it would be person A. And the reason for this is because person B was unaware or ignorant of the ruling. And the reason why we will not take the mubashir to account is because from his part it was not intentional murder, because he did not even know that murder was haram in the first place. What about if the ruler orders a person to kill somebody else? Well, here we have to look. If we know the ruler to be an oppressive ruler who murders people and takes advantage of his authority, then in a case like this, it is not permissible for any man to comply with the order of this ruler, because there can be no obedience to any human in that which is disobedience to Allah Jalla wa Ala. As for if we know that the person who is being ordered to be killed is somebody who is allowed to be killed, or someone ordered to be killed, for example a harbi, then in this case you are allowed to obey the ruler. Otherwise the asl is that the people's blood is not lawful to be spilt, unless you are sure otherwise. What about a scenario where two people kill the third person, and only one of the two killers is eligible for qisas and the other one is not? For example, a man teams up with another man to kill his son. Now if the son is killed, then according to majority of the scholars, the father is not killed for his child. So in a case like this, the father's partner will be killed because he is not the father or the parent of the child, so he is eligible for the qisas, but the father will not be killed. And the only thing upon the father would be half of the diya, or the blood money, because the other half would be upon the partner of the father, but because his revenge was the qisas, so we cannot take blood money from him, it leaves the father to pay his share of the blood money, which would be half of the blood money. Similarly, with a free man and a servant killing a servant, there would be qisas upon the servant but not upon the free man, according to the majority opinion. Similarly, with a Muslim and a kafir killing a kafir, the qisas is upon the kafir and half of the blood money is upon the Muslim. But what about the case if we have an intentional murderer and an unintentional murderer combined to kill someone? For example, person A wants to intentionally kill person C, so he goes to him and stabs him to kill him. But at the same time there is a person B who is hunting a game animal, so he throws his spear and the spear accidentally hits person C. Now person C dies because of the spear thrown by person B accidentally to him and the intentional stab from person A. So in a case like this, what do we say? Are they both responsible? Some scholars say that the qisas is upon person A because he intentionally murdered person C, and person B simply has to pay the blood money of unintentional murder, and this would be half of the blood money. However, upon this though, some scholars have disagreed. They say that we don't know how person C died. Did he die from the stab of person A, or was his death confirmed because of the spear of person B? We don't know. Therefore there is no qisas upon anybody. Okay, so let's move to another issue. When the qisas is taking place, how does this happen? Well, the first point to note is that it needs to take place in the presence of the imam, who is the ruler, or his deputy. So he needs to go through the official channel. If somebody takes the qisas without the permission of the imam, then this qisas is all well and good, but the person who undertook the qisas is to be given a ta'zir punishment for evading the imam and not going through the proper channel. And if it is taken in the presence of the imam, then who does the killing? We say that the relative of the victim does the killing, as long as he is able to do it properly. If he is not able to do it properly, by striking the sword on the neck of the perpetrator, or however you have to kill the perpetrator, remember al-qisas is that you kill him in the same way he killed the victim. So if the relative of the victim is not able to do this properly, then he has to leave this job to somebody who is able to do it properly. As the Prophet ﷺ said, فَإِذَا قَتَلْتُمْ فَأَحْسِنُوا الْقِتْلَةِ If you kill, then you must kill well, because Allah has prescribed goodness and efficiency in all actions. So we find it is not necessary that the qisas be taken with the sword. Rather, however the perpetrator killed his victim, that's how you kill him, as long as the action in and of itself is halal. So you're not allowed to, for example, use khamr to kill this perpetrator. Or for example, if the perpetrator ate the intestines of his victims, you are not allowed to eat his intestines, because this is haram in and of itself. But as for the general rule, then you kill him the way he killed. Allah Jalla wa Ala says, وَإِنْ عَاقَبْتُمْ فَعَاقِبُوا بِمِثْلِ مَا عُوقِبْتُمْ بِهِ. And when you punish, then punish them the same way they transgressed against you. Likewise, وَجَزَاءُ سَيِّئَةٍ سَيِّئَةٌ مِثْلُهَا. The reward of an evil is an evil like thereof. And then we have the hadith of the Yahudi crushing the head of the girl between two rocks as well. And even if we reason it out, it could be that the perpetrator horribly kills his victim, and then we are just going to chop his neck off. No, that's far too good. And he does not deserve to die in such a nice and peaceful way. Rather, he has to die in the same horrible way which he inflicted on his victim. Okay, let's take some review questions. So question number 1. Explain the difference between a conspiracy to murder and a group of people simply attacking another person and manage to kill him. What would be the difference in a case like this? Question number 2. Explain what must be done with a ghila type of killing and why. Question number 3. If person A forces person B to kill himself, would we hold person A accountable? Explain the answer.